I'm still waiting for whoever collected the assignment. I don't know. Coming up due next tomorrow. Tomorrow, right? Yeah. So I'm sure all of you have been putting in your best for this particular assignment, and likewise, the exams are on week 17 or
First week of June.
so we got a month and a few days. Yeah. So we're not going to deal with a topic which is not related directly to, well, it is related to income taxation, but not to the core subject matter. This one is to do with administrative aspects of the law, which is a little bit lighter and a bit more easier to follow. This particular chapter or course topic has been selected because, in my view, it's important for lawyers to understand how does the process work in terms of trying to dispute a particular assessment and or knowing what are the powers that FOCA has, FOCA being the Fiji Revenue Customs Authority. Because one day when you get out there, while you may know the text and you may understand the law, like what we have been discussing for the last 11 weeks or less than that, if a client comes up to you tomorrow and says, what can I do? How can I contest it? How can I challenge it? Then you have to be able to give some advice to a client. So this is what we're going to talk about. And it's going to be, I think, a bit more easier topic to digest compared to other areas of the income tax law. And I would also want to say that there will be, I can tell you now, there will be a question on this in the exams. So I have made an effort to put something on this. If you study this well, you will easily get at least another 10 marks or something. I think is worth in the exam. So that's just a hint. So the main topics that we're going to discuss today are set out there. We're going to try and understand what is a tax assessment and a tax decision, understand tax dispute processes and procedures. We have to understand how we can resolve a tax dispute, and also understanding the powers of the Fiji Revenue Customs Authority when it comes to recovery of taxes and the implications that arise as a result of that. Now, for the purposes of this particular chapter or course, or this particular area of law that we're going to look at, the Tax Administration Decree of 2009 is relevant. Now, as far as the exam is concerned, I know that I've discussed this with Shivendra, that we will allow students to bring in the legislation into the test. So you can bring your Income Tax Act, you can bring your Value-Added Tax Act, which we will discuss next week. And you can also bring this particular law. So there will be really three areas, or three legislation that you can bring into the exam room. The rest, it's not an open book exam per se, it's just these particular pieces of legislation you can bring into the exam. So take a note of that. And if you really want to get good marks, I would suggest you make a copy of this particular law, or somehow make a particular, I don't know how you do it. You want to photocopy it where you can put 2 pages in 1 page, something like that, do that. But you need to have this, because this might help you in answering some of the questions in the exam. As I was saying in the beginning, I think I've jumped the gun actually. Why is it important to understand tax dispute and processes? Like I said, you have to be able to provide advice to your client on how you can go about disputing tax assessments. You yourself will be a taxpayer one day, so you want to know for your own self what you can do to challenge an assessment or a tax decision. You also have to understand what are the consequences if you do not challenge it or you do not take advantage of the provisions in the law to protect your side of your dispute. You also have to understand the vast powers that the Fiji Revenue Customs has in relation to their collection of taxes, and very importantly, even if you object to an assessment, we'll talk about that shortly, or appeal an assessment, you still have to pay the taxes. Even if you have a valid dispute and you strongly disagree with FOCA's position, they have the ability under the law to carry on collecting the taxes, whether you like it or not, even if it means having to pay a substantial amount of taxes. It can be unfair, but that is what happens. The debt recovery powers, which are also in this legislation, are very strong, and sometimes you are prevented from traveling abroad. Like I said the other day, some people have departure prohibition orders. That all comes under this law, not the Income Tax Act or the Value Added Tax Act. It comes from this particular provision. So even businesses can be affected because they can put a restraining order on your business, they can close your business down temporarily. So those are some of the impacts of the powers that they have. So this particular law, the Tax Administration Decree 2009, as you can see, it was known as a decree then. It's now an act because the government just recently has made all decrees acts. But at that time, it was a decree. So when you're writing this particular provision in your assignment or your exam answers, if you use the word decree or act, it doesn't really concern me that much. So you don't feel obliged to use the word act or decree. Whichever way you go is okay with me. As long as you say tax administration decree or act, it's fine. Now the law says, this particular law has a schedule in the back. The schedule will say, where is the schedule? Yeah. It is the section 2, the second schedule. The tax administration provisions apply to the following legislations: Income Tax Act of 2015, the VAT decree, the Service Turnover Tax decree, Gambling Turnover decree, and any other law where tax or levies are imposed. What that basically does is that instead of previously the VAT decree had its own administrative provision, the Income Tax Act had its own administrative provision, and other laws had its own administrative provision. What we did when we were in FOCA, and I was fortunate to be part of it because this was when I was there, was we harmonized everything. We took out all the administrative provisions, all the recovery position, tax recovery provision, and we centralized it into one law and left the other laws to deal with the pure income tax stuff, the VAT stuff, the capital gains or the service turnover, whatever it was. They deal with the pure stuff. But the administrative aspects, they all apply to each of these laws. So this particular law is one, but it applies to all these laws that have been stated out there. Those that relate to tax or VAT, for example. So if you have a VAT case under the VAT decree, value-added tax decree, and you have a dispute under that particular law, you will go to this particular provisions to find out how you can contest it. You go to this law. If you have a dispute in the Income Tax Act and you say, hang on, I don't think I should have been taxed for all these things, you still have to go back to this law. There's no administrative provisions in the Income Tax Act now. The value-added tax still has it, but they do not apply because they've all been repealed by virtue of this. There is a repeal provision here which will say all those things have been repealed, and it's in the back. But that's not what we have to focus on today. But I just want you to understand that when it comes to administrative aspects of all these laws, you turn to your eyes to this particular legislation. So I think you all follow that. So this is your Bible in relation to any tax matter, administrative aspects. Now, we're looking at specifically at disputes. That's why we're lawyers, and we're interested in the disputes that happen. Now, there are two main areas, and you need to get your head around the word assessment or amended assessments. That's a word you're going to hear quite often, particularly when you're out there in the real world practicing law. You're going to find yourself receiving notices of assessment, or amended assessment. They're issued by FOCA, and in notice of assessment it will set out a number of information. It will set out the period for which it applies. So for example, if it's relating to the income year 2018, it will say there 2018 or 17, whichever year, it will say there. It will also provide a breakdown of your gross income that you earned for the year, or net profit, whatever it may have been. And then there will be some computation which will then have the tax amount, and then it will say you have to pay X amount of money to FOCA, or there's a refund. Sometimes there's a refund if you're lucky. When that notice comes to you, that then triggers off a whole set of reaction that can happen after that. But that is one important thing. The tax assessment will have a number on it. I haven't got a precedent of a tax assessment here, but I can show you later on. Maybe I'll post it up on Moodle, so you can have an idea of what a tax assessment looks like. But it's not a very difficult thing to understand, but once you have a look at it, I'm sure you'll be better off. Amended assessment. Now, amended assessment happens when, say for example, you've lodged your tax returns. FOCA has initially issued an assessment saying you have to pay $100. Fine, you paid. But then later on, after a few years, FOCA says, oh, we've done an audit of your business and we think your income wasn't $100, or your tax payable isn't $100, it's actually $10,000. They've gone up. So they will then issue an amended assessment. Right? And these provisions that allow amended assessments are in the legislation. And I think I'll just show it to you. I haven't put it up there. So let me just. Yes, amended assessment is in section 11. Advanced assessment, there's also a thing called advanced assessment. Advanced assessments are made before the actual tax return is to be lodged. So for example, FOCA has an idea or some information that there is a potential tax being payable by the taxpayer. But before the taxpayer lodges his tax return, they themselves compute it. It's a bit unfair, but they do it because sometimes taxpayers are about to flee the country. They're going to leave the country. They haven't done their tax return, but we know how much they earn from the activity they did in Fiji. And so we will issue an advance assessment so that they can be caught within the net. Because if we don't issue an assessment, the taxpayer is free to travel. There's also a thing called default assessment, section 9. That's in the absence where a taxpayer does not lodge a return. So section 9 deals with default assessment, section 10 deals with advanced assessment, section 11 deals with amended assessment. Now, the other area, which is something new, which was introduced by virtue of this particular legislation, is that you can also have a dispute in relation to tax decision. Now, tax decision also includes an assessment, but it also includes other things. And I will tell you what that is. Yeah, so I seem to be jumping the gun everywhere. Sorry about that. Okay, well, it's there. Tax decision is a decision under tax law which is left to the discretion, judgment, direction, opinion, approval, consent, satisfaction, or determination of the CEO. So it can be a range of decisions made by the CEO of FOCA, which can become subject of a legal dispute. I'll talk about that a bit later on. I just seem to be going ahead of the slides. Okay, so why do you think we have disputes with FOCA? Firstly, we may disagree with the way FOCA has interpreted the law. We have discussed this over the last 11 weeks about areas in which sometimes the legal interpretation of a particular word or group of words or sentence may be at odds with what you are saying. And that's why we have a whole body of cases uh, Fiji and abroad, which deals with these issues. So therefore, that may form a basis of a dispute. Uh, you may also take a matter to court or to objection because you yourself are not satisfied with the interpretation of the law. You feel that maybe you need to test the law to see what the courts will say about it. So you're yourself not satisfied, maybe because it's ambiguous, it's vague. So it's also in your advantage, if you take it to court and get a decision from the court so that it solves the problem once and for all. That's one way of doing it. And another way of doing it is basically to get an external review of a matter where FOCA doesn't agree with you. So you're just asking for some third party, which is the courts in this country, to make a decision about a particular area of law. And a lot of people do it for commercial reasons, because they want to resolve a particular meaning, or they want to resolve a particular interpretation of a law, so that going forward they don't have any further issues. Because as you know, businesses are here to stay, taxpayers are here to stay, and they will keep lodging tax returns every year. So it's always good to have some finality and know what the courts have said about a particular kind of transaction or income or expense or deductibility, and that's how you would know what you're going to do going forward. So those are the kinds of situations where dispute may arise, and why you might want to take it to court. I think I covered this a bit ahead of myself, but tax assessments can be issued under various laws, and they include the Income Tax Act. If you look at the first schedule of this particular legislation, it has a set of when and where tax assessment. What are tax assessments? Tax assessment is an assessment of income tax. It's an ascertainment of provisional tax or advance payment of tax. You don't have to worry about it, but I'm just explaining to you what it might cover. Capital gains tax is also an assessment of tax. If they issue a document, it is also an assessment. So these are the kinds of assessment. You also have fringe benefit tax assessment. So that's in the first schedule. Okay, now what can we do before we start the legal process at a time when we have a dispute? Now, in FOCA, they have what we call an internal process. Not really an internal process, but it's like it affords a taxpayer the opportunity to respond to the initial position, FOCA's initial position, which is so and so, we think you should be paying taxes on these amounts because of this. They will set it up. They'll send you a letter. They haven't issued you an assessment, because once an assessment is issued, then the timeline starts running, and then you are confined to what's in the law. FOCA is also bound by what's in the law, so they are also confined as to what they can do. So sometimes FOCA is also not so sure. Maybe the investigation has revealed a lot of information, but not everything. So they will send a notice of discrepancy to you, saying, so and so, we think you should be paying this much tax because of these reasons. They put the numbers there and so forth. There's some calculation there. And then that person might get his accountant, or he himself will write, or his lawyer will write to FOCA saying, no, I think it should be this. And eventually they're able to probably narrow down the issues, agree on some things, and then they might even solve it there and then. It will finish at that point. Or the amount will get less. In some cases it actually gets more. You never know what can be the outcome. So at the first dot point is very important, because why? There's no timeline starting. You're just having this informal discussion. I had a case just recently completed, but it had been going on for 2 years, but it was at the notice of discrepancy stage. There's nothing in the law about the notice of discrepancy. In this particular law, there's nothing in there about notice of discrepancy. This law is more black and white, but this is a procedure that FOCA themselves have come up with. They're not obliged to do it, but they do allow it as a matter of due process for fairness to the taxpayer to allow them to give their comments before they actually issue the final notice of assessment. As I said, the notice of assessment triggers off the whole timeline. It also means when you're dealing with a notice of discrepancy, you don't have to pay the taxes at that point because they haven't issued an assessment. Once an assessment is out, then you are obliged to pay the taxes. And that puts a lot of pressure on businesses and individuals who may not have the means to pay the money up front or haven't contemplated paying. So they don't have the pressure of paying up. But once an assessment comes out, then they're under pressure. And so this mostly applies in audit cases. Audit is where FOCA carries out an audit of the taxpayer. They will send a group of people to your office or your business. They will go through your document. They might take some of the documents away to FOCA. They'll do their analysis, research. They will discuss it with the legal people. They might even get a forensic accountant to go through the information, cross-check with customs if it involves customs issues, and then they will send you a letter. So audit is a big thing for FOCA, and I get involved in a lot of these things because of the nature of it. Sometimes the caliber of people who are there is also sometimes an issue why some cases drag on for so long, because they're not able to understand complexities in accounting concepts or in terms of the law. But anyway, that's beside the point. With this particular law, or with this procedure, as with any other procedure in this law, you have to follow the timelines. They're very strict about it. We will talk about that shortly. And if you don't follow timelines, you don't respond to them, you can be caught out. The third point is to provide all information at that point. It's very important to do that because later on, when you have a matter in the tax court, if you are relying on matters that you haven't shown to FOCA, documentation or arguments, or your points of appeal have not been canvassed at the earlier stage, you won't be allowed to use it at a later stage. So it's very important. Now, let's assume for this purpose an assessment has been issued. We'll just worry about assessments. So what the law says under the administration law, this particular law, is that an objection has to be lodged within 60 consecutive days from the service of the tax assessments. Right, the notices of assessment. That's under section 16(1)(a) of the tax administration decree. And that particular provision is the one that we always use when we are filing an objection. Now, what does an objection look like, or what is it actually? There is a form, it's on the FOCA website, which has to be filled out. It will set out, it will require you to fill in a number of information, particularly your taxpayer's details. It also will require for you to say what particular assessment are you objecting to. You've got to be very specific. Oh, I am objecting to last year's assessment because I think it's excessive, but I'm okay with the previous other one. So you've got to just focus on the one that you're going to object. So you have to put details, and then you can attach your arguments, your summary, your submission. That is also submitted. Now, once that is being so that's in relation to assessment. Sorry, that's in relation to assessment. Now, you may recall I had shown you a slide dealing with tax decisions. Tax decisions are separate from the tax assessment. They are any other decision made by the CEO, which is left to his discretion, his approval, and so forth. It's a very ambiguous provision, and it hasn't been very well covered or well thought out, in my view, because it's neither here nor there when it comes to tax decision. Because any decision, there's so many decisions that the CEO makes. For example, a decision to impose a departure prohibition order, whether that is covered under the second part. But assuming that is covered, then you only have 30 days to object. Assessment 60 days, and other tax decisions 30 days. So there are two different segments. You will have to look at the law to see that. I made a mistake here on the slide. It should be 16.1b, the second dot point, 16.1b, not a. Sorry about that. I've mentioned dot point 3. You must put all your evidence in, all the documents that you intend to rely on, including your arguments. What are your key points of your argument? That has to be submitted to FOCA. Now, sometimes, in very odd cases, but it does happen, a taxpayer may not be fully aware or not knowing how the law works and being very casual about it, which a lot of taxpayers in PG are. They may not actually lodge an objection within 60 or 30 days. And there is a provision in the law, which is important for you to know, is that the commissioner, the CEO of FOCA, has the powers to entertain late objections, but only where they are reasonable cause. So he won't give an extension of time in every case. It is very hard for him to, I think only in rare cases he's ever done that. So there is some flexibility for the CEO to entertain late objections. Now the good thing is that this particular law says that once an objection has been received, the CEO of FOCA has 90 days to make a decision. 90 days. He can make inquiries and all those things, and if it goes beyond the 90 days, that there is some flexibility there. But it won't be just, the CEO has that obligation to do it within 90 days. I just wanted to have a look at this section again. I don't know where it came from, but that particular thing is supposed to be 16.7. 16.7, not 16.8. Again, I don't know where that typographical error came from. 16.7. You see, what happens is that when sometimes an objection is lodged, the CEO sits on it, administrative reason. They don't, and maybe they're also confused. You will be surprised how confused they can become. So they're very confused because sometimes the arguments made in the objection are prepared by lawyers, experts, accountants, overseas counsel. They put a lot of detailed submission on the law and interpretation and all that. And when a person is assessing it in FOCA, trying to deal with his objection, he could be lost. And so what happens is that they sit on it, and the time just goes. But remember, if you sit on it, it's to their advantage, not to you, because you have to still pay the taxes, and your case is not being resolved. You see, it's unfair. You see, because FOCA has the beauty until this law came in, they could sit on it. They would still be collecting your taxes, and you'll be saying, hang on, where's your decision about my objection? So it's still under process, 1 year goes by, 2 years go by, and then you're hanging around there. You've already, by the time they come back and they say disallowed, you've already paid $500,000 or 200,000, whatever the amount is. It depends on how big your business is. So I remember that when we were doing consultations in relation to this law with the accountants and the lawyers, the KPMG, the Mandulis and all that, they wanted FOCA to be under some pressure to deliver a decision within a reasonable time. So that's why the 90 days was inserted. It wasn't there on the original draft of this particular law. So that's good. So they have 90 days to decide, and only in exceptional cases can they go beyond the 90 days, but it should be within the 90 days. Now, this is very important because I have one case still going on right now, but poor taxpayer doesn't understand. But what happens is, you look at dot point 1, is that if you don't lodge an objection against an assessment, for whatever reason, you choose, maybe you think it's too costly to do it, or you forgotten about it, or you trying to resolve it without following the process here, by just having meetings with FOCA and all that, and the 60 days goes by and the 30 days gone by, you don't lodge any objection. What happens is that the law says that the assessment or the tax decision is treated as valid and binding upon the taxpayer. So it may be technically still wrong, but you're stuck with it. And you can't come back 5-10 years later on and tell the lawyer or FOCA that, hey, hang on, that assessment that they're pushing me to pay, I shouldn't be paying that because of the following reason. You can't. You have to say, look, you're out of time, your 60 days is gone, and this provision creates a situation where it is deemed valid and binding. It's valid and binding not only to the taxpayer, even though it only specifically says the taxpayer, it's also valid and binding to the CEO of FOCA. So he has to carry out that particular assessment. So if you say you have to collect 1 million, he has to go and collect 1 million. Even though maybe after 5 years later everybody thinks that it was the wrong decision. But the CEO does have the powers to come back and say, okay, I'm going to reassess using his own powers. He has ancillary powers separately where he can. But it's through his own action, not through the taxpayer. So the second dot point is basically saying that if you disagree with an assessment, you must challenge it. You must take steps to object, and if need be, to appeal if the objection is not successful. If you don't challenge it through the process set out under the law, which is the objection and later on the appeals, which I will discuss shortly. You can't go to any other court to challenge the assessments or the tax decision. This is one area that troubled a lot of people in the beginning. It's because, sometimes people will try and go on a judicial review or file an originating summons in another proceeding. And a lot of lawyers, they do it quite foolishly. When I was in FOCA, and even now I have seen some lawyers doing it, but it's getting less now, is that 60 days or whatever has expired, and they even know that there is a 60-day limit or a 30-day limit for appealing to the court, but they will want to file a different action by getting some declarations and all those things and originating summons and trying to deal with the assessment through another proceeding, which is not catered for in this. And this particular provision, the last dot point, is saying you cannot challenge your assessment through any other court processes. It has to be through the process set out in the law, this particular law, or some other law. You can't file a writ of summons, you can't file a originating summons or a motion or whatever in another court. It has to be all in the tax tribunal or the tax court. And if you haven't used these proceedings set out in this legislation, tax decision is final, and then you're stuck with that. Okay, so now let's say we're going step by step. Objection has been lodged, FOCA has had their time to review it, and they've disallowed it. They will write a letter to you saying that the assessment that we issued, subject of the objection, still stands. Then you say, okay, well, I'm stuck now, I still have to fight this out, I'm going to take it to the tax tribunal or the tax court. So that is also a provision set out in the end, or the decree. And it starts from section 82, which is a set of laws or sections that specifically deal with challenging the decision, the objection decision. That's another word that you must get familiar with, which is going to be used quite a bit when you get out there in practice. It's the objection decision. The objection decision is the decision made by the CEO in respect of your objection. Okay? And if you want to challenge that decision of the CEO, you have 30 days to do it. 30 days across the board. It's not any more or less. It's exactly 30 days. 30 consecutive days, so it includes weekends and all those things, public holidays. What I actually filed is not a notice of appeal, but an application for review. You're reviewing the decision made by the CEO. The objection decision made by the CEO, you're not actually appealing it, but even though it is actually in the end the same thing, but you're actually reviewing it. You're asking the court, the tax tribunal or the tax court, to review the CEO's decision. So try and get your head around that. So it's not to be confused with a notice of appeal, even though it does look very much like a notice of appeal. If you looked at a notice of appeal, you would know what it is. And the formatting and everything is the same. The tax tribunal is a magistrate court level court. It is not of high court level. So the jurisdiction of the tax tribunal is limited to 50,000. But where both parties consent, if the amount in the assessment is more than 50,000, you can have it heard in the tax tribunal. You can actually have it heard in the tax tribunal. But if you both consent, or if at least FOCA consents, it's really the taxpayer's choice. If he says, I don't want the tribunal to deal with this matter, because I think the tax court, which is the high court level, will be more capable of dealing with this complex area of law, then I will nominate to have it transferred to the tax court. FOCA can object, but they don't object because they don't have the authority to do that. But once a taxpayer says, I elect to go to the high court, tax court, then that's what happens. It goes automatically up to the tax court. So I do that all the time. When I have my cases in court, I normally, in every case except maybe a few, I've always gone to the tax court because all my cases have always been above 50,000 in terms of assessment. 50,000 is a very small number when it comes to tax. To us, it looks big, but when you're talking about taxpayers, businesses, 50,000 is a very small amount. It's normally about $500,000 like that, or at least $250,000 above. In an average case, if you look at it, they go into the millions. So you don't want the tribunal to be dealing with it, but it's not to say that you don't have the confidence in the tribunal. It's just that you feel maybe a high court judge with more years of experience. Because remember, a tribunal is someone of a magistrate court level who may only need, I think, about 7 or 8 years of experience to become a magistrate, or is it 10 years? Whereas a high court judge has far more years of experience. So the tax court is the high court. Just remember that. Tax court is the high court. You already know the court structures: the magistrate court, the high court, the court of appeal, the Supreme Court. That's the 4 levels of court in this country. So magistrate court levels include the tribunals, including the sugar tribunal, the employment tribunal. Those are all magistrate court level. When you hear the word tribunal, it's all magistrate court. The same thing with the tax tribunal as well. The current tax tribunal is Mr. Andrew C., who's also the employment court, employment tribunal. He was the one who dealt with the AFL, or what's it, not AFL, ATS dispute. He also sits in as the tax tribunal. Now, once the appeal is lodged, or the application for review within the 30 days, then FOCA has a timeline too to start doing something as well. Once they serve the document, the appeal, the application for review, they have 28 days to serve, or what we call lodge their documents. This is their document which they think support their case, and they must also provide a summary as to why they think their position is correct. Section 83, a statement setting out the reasons for the decision, if these are not already set out in the notice. So they can provide their reasons, in a small, maybe 1-pager, in just a dot point. They can set out in a few paragraphs or in a few sentences why they have assessed this particular taxpayer. So that's the 4th dot point there that you see. And that's all part of due process, because you want to have both parties revealing their hand, not to hide information. If you look at a lot of TV series, you always see people ambushing parties on the other side. You know, the ones that you see Suits. I've been watching Suits a lot. I don't know whether you heard of that program. It's a legal drama, but they're always ambushing everybody in the courtroom. That doesn't happen in real life. There's no ambushing business because everything is disclosed before the case is actually heard, well before the case is heard. You have the process of discovery. If you've done civil proceedings, have you done civil procedure law? You would be familiar with the concept of discovery. The same thing also applies in criminal cases. There's a discovery through disclosures, where evidence, witness statements, and other document exhibits might be copies of exhibits, whatever it may be, photographs, they're all provided. The same thing happens in the tax matter too. The last point is, which is very common and you're familiar with it, I'm sure, you've heard of it. Both parties will normally try to get together and prepare a consolidated, agreed facts and issues. That's a legal paper that is filed in court, and normally we take time from the judge to go and do this. We set it out, what are the facts, because a lot of the facts can be agreed upon. But yes, some areas you might not be able to agree on, so you leave them out. And then you set out what the issues are. It could be a factual issue, it could be a legal issue, but you have to set it out. You also might mention who the witnesses you want to call, or what kind of evidence, hard evidence you might want to adduce, including documentation. So all those things are normally provided before, well before a hearing. Now, the onus of proof is on the taxpayer. It's not the tax office who has to prove that their assessment is right. It's the taxpayer. It's the taxpayer that has to show that the tax office or the CEO FUCA is wrong. His assessment is incorrect. The burden is on the taxpayer. He has to bring all the documents. He has to do the hard work. He has to call all the evidence. The court will sit back, or FUCA will sit back and let the taxpayer exhaust himself, and then they present their case at the end. The standard of proof is balance of probabilities. That's the normal case with all civil matters. It's not beyond reasonable doubt, so that that's good. That's good for taxpayers, because if it was beyond reasonable doubt, it would be a nightmare to win any case. So balance of probability, 50-50. Yeah? Now, what are the powers of the tribunal? What is the powers of the tribunal? The tribunal, after hearing the matter, he has the same powers as the original decision maker, the CEO of FOCA. He can use some power within this law or some other law to amend, change, to recompute if he feels necessary. He can sit down, so he's got a lot of powers. If the tribunal feels that FOCA was not right, he can make the adjustments, and you just have to accept it because it's provided for in the law. Section 82 provides that. Yes, Section 82, subsection 5. Just to add to that, 82, subsection 5. The tax tribunal may, in reviewing a reviewable decision, exercise all the powers and discretions of the original decision maker under the tax law under which the original decision was made. There may be time when, in the middle of the proceedings, the tribunal may, because of the complexity of the matter, and maybe the parties are struggling or something like that, and the court might not be the right place to deal with it at that very moment. There's some point in the argument or in terms of the calculation that it might be advantageous to send it back to the CEO, because he may have when he's back in his office or whoever is there in FOCA, to go through the calculations again and maybe do the adjustments and then come back to the tribunal again. So he can, in the middle of the proceedings, send the matter back to the CEO just to quickly review some particular thing like calculations or whatever it may be, and then it comes back to the CEO, to the court, sorry. Yeah, that's section 86. Section 86. In fact, this happened in one of my cases, one of my earlier cases, where during the middle of the proceedings, it became obvious to FOCA and to the tribunal that our position was correct, that FOCA had completely misconstrued a certain facts and treated certain payments as income when it wasn't income. But it only came out because the taxpayer, unfortunately, was a lawyer as well, who I was representing. And you know, lawyers are always argumentative, and they don't like to give anything away. But had he called upon me earlier, I might have been able to resolve it before going to court. But it was only when it was fixed for hearing that he asked me to help him in his case. I said, okay, I'll do it. And I went through the case. It was hard to understand, but I eventually got the nub of it. It was basically, in that case, he had two accounts and he was making loan repayments to the second account. So he had an overdraft facility and he was making payments across to the operating account. FOCA was only looking at the operating account and thinking that all this money is coming from sales of something, you know, that he hasn't been declaring. But he could have so easily explained that those money were coming directly from this account, which was an overdraft facility provided by the bank because he had applied for a loan in relation to a land development activity that he was doing, and that these payments were actually just going across to for some reason I can't remember what, but in a nutshell there was a source to that payment, right? It was from the loans, but FOCA always treated that as income. Once it became obvious in court, then they backed off, and then they said, oh, I told them, we sit down, let's quickly just sort it out. We went back to FOCA. The judge allowed us to go back, you know, sort of like remitted the matter back to CEO. Then once we agreed on everything, they reversed all of the figures. The taxpayer had a refund then, didn't have to pay FOCA. Then we came back to the court, the tax tribunal, and we filed the orders. We got him to then, we did a terms of settlement, and all the figures were reversed, and the court then accepted it. So it did not have to make a decision. It didn't have to make a decision on the case, because that allows, this kind of process allows flexibility, which in other courts you might not get. If you're in a magistrate court cannot send it back for the parties to determine it themselves. You see, so this law is actually quite flexible in allowing the parties to go back if the court feels fit that it can be resolved. Not necessarily the whole issue, but part of the issue can be resolved. And so that gives the court that power to send it back. And that example was one of them, where I thought it was made of good use of. Now sometimes the tax tribunal also might be grappling with a legal issue. It doesn't quite know what to do in terms of interpreting a particular law. Maybe he just doesn't have the knowledge or the experience, and he feels that it might be better off if he refers the question of law to the tax court, which is the High Court. A High Court judge sits there, and he, the tribunal, may say, I'm going to refer this question whether the law says in the Income Tax Act is requiring so and so. He poses a question, parties agree to what the question should be, and then he sends it up to the tax court. And it happened once. There was a case, and I think it was Namosi Joint Venture. Namosi Joint Venture and the CEO of FOCA, where that one, there was a question of law that was sent up to the High Court, and I think the High Court made a decision, and then I think it had to come back. I think it was that case. So these particular provisions of the law have already been used by taxpayers and so forth. So Section 87 is the one which allows him to refer questions of law to the tax court. So he can refer it up, he can also refer it downwards. So he's got both powers. So the tribunal is in a lucky position. Now if you have a matter in the tax tribunal, because it's of the magistrate court level, the magistrate court rules apply, not the High Court rules. But in the absence of specific provisions in the magistrate court rule, then the High Court rules apply. So that's how it generally is across the board. Even if you have a case in the magistrate court, if the magistrate court rules don't provide you something in relation to some procedural aspect, you can use the High Court rules. Yeah, so the first dot point was what I was trying to say earlier, but it's slightly different. This one here, you look at this slide. Section, the one I had earlier, section 87 was a question of law, but it also had in section 88 too. The tax tribunal himself may decide to transfer a matter to the tax court if he is of the view that there is an important question of law likely to arise, or the case is of such a nature that it is in the public interest. Now, the first one is this one, the question of law. He's not telling the tax court to make the decision. What he is just asking the tax court is, just tell me what is the interpretation of this. Once you tell me that, then I will use that interpretation to decide this case. Right? And then I will look at the facts and see whether those facts match what you are now saying is the interpretation of the law. But section 88 allows you to go one step further and actually transfer the matter completely to the tax court, so that the tax court can make a decision on the entire case. Because the matter is of public interest, there's an important question of law, and there's some urgency in relation to it. Sometimes you have those situations where the taxpayers or a body of taxpayers are very interested to know what will be the outcome of a particular case, so they then expedite it. They take it up to the tax court so that they can quickly make a decision there. So again, a lot of flexibility is there. This particular provision, as you will see, you will not find it in other areas of the law. Maybe the Employment Act, possibly, the Employment Decree, ERP law. But it will give you an idea of the kind of situation that are now catered for in our law, which was never there in the magistrate court rules, which were never there in the high court rules. These avenues that are available to the court and to the parties to explore is now provided for. So much so that in dot point number 2, you will also see that, as you know, tax matters are personal to you. We have to understand, we don't want every Tom, Dick and Harry to know how much we're earning or how much we made from this sale. We want it to be confidential, don't we? And the tax tribunal, if you do a case in the tax tribunal, that is already there. If you read the judgments of the tax tribunal, particularly the last 5, 6, 8 years, he doesn't refer to the parties by their name. He doesn't say Vinod Patel or Asim Manubai or whatever. He will say hardware company A, investment company B. He will give those kind of notional names just to fill in the gaps, because he is aware that he is not supposed to disclose the parties' names. That's somewhere in the legislation, and maybe I'll leave that to you to find it, because they are. Yes, I'll just tell you the section. It's section 89, subsection 6. In publishing a decision, the tax tribunal must ensure that the identity and affairs of the applicant, person who is making the appeal, and any other person concerned are concealed, and trade secrets or other confidential information are not disclosed. Because, you know, if we discuss something that is very specific or personal to the business, not personal, but is of an asset to the business, then everybody knows about it once they read the judgment. So he can restrict publication of that kind of information. And quite rightly so, because as I said, taxpayers' information should be kept confidential. But when you get to the tax court, it doesn't quite apply, because this particular thing applies only to the tax tribunal. It doesn't. The same provision is not there for the tax court. And I have looked at the judgments of the tax court, because obviously I have a number of them under my name. They actually do disclose the names of the party, but only if you make an application before the tax court, then you can have it made or you suppress the name, keep it confidential. Now the third dot point was also something that the accountants and the lawyers came up with from the other side, because sometimes the ruling went in favor of the taxpayer, but FOCA wouldn't implement the decision. That was another big problem that a lot of taxpayers had, where the court said, please, this is found in favor of the taxpayer. So when the court says that it is found in favor of the taxpayer, FOCA has 45 days under this law to implement it. What does it mean by implementing? It means to reverse or to partly reverse whatever is the decision of the court. And sometimes, and in most cases, because taxes is paid up front and they have to pay, the hearing might take place 2 years down the road. You've already paid the taxes. And in most cases, many of these big companies have paid the taxes in the first 6 months. So, if they win their case, then they have to be refunded. This was the problem. FOCA wouldn't very easily refund them. That was one of the problems that we had. And I knew it was a problem because I was in the system. But in some cases, you have to even refund and also give interest on the refund. So that was another problem. The lawyers and accountants, the ones that I referred to earlier, they said, we want FOCA to be bound by this ruling, and they are bound, but they just don't implement it. So now they're saying, no, you must implement it within the time frame. So we agreed, we made some concessions, and we agreed. I was part of that negotiation discussion, and that the CEO would have 45 days to make the changes, to amend this, provided the taxpayer won, so that it could give effect to the decision. And if he didn't do it within the 45 days, then the taxpayer could apply to the court using Section 93 of the Act to compel the commissioner to comply with it. And if he didn't do it, then he would be in contempt of court, basically. So that was a protection available to the taxpayer. So you see, there's a balancing exercise, balancing the interests of the Commissioner of Inland Revenue to collect revenue for the state, but also balancing the interests of the taxpayer, making sure that there's a bit of a level playing field between the two, because normally things are very much in favor of the tax office. Now, if the ruling from the tax tribunal is unfavorable, you can then appeal to the tax court. So from the tax tribunal, you can go to the tax court, and that just is a normal appeal, and you can appeal on, I think it's facts and law. Let me just check. You can appeal on both facts and law. Right? So if he has made a finding of fact which you disagree with, you can also appeal against that, and also a finding on the law, you can also appeal on that too. As you might know, when you get to the Court of Appeal, from there, then you cannot appeal against a finding of fact. You can only appeal on a finding of law. So those are, and there was a judgment, that came out recently where FOCA got into a problem because the appeal was on a finding of fact. It wasn't very clear enough. And the case was dismissed by the Court of Appeal, even though they had a good case, but the appeal grounds, the way they had drafted it, was not clear enough. It should have been restricted to finding of law, and then they might have got away with it. So the Court of Appeal, Justice Calancini, he overturned it, not overturned, he dismissed the appeal on the first instance. They didn't even actually hear the substantive issue. I'll try and find the judgment and put it up, but it's not that important to know it. So you go to the tax court. Oh, I think I deleted one line there. not sure what the last sentence was saying. This is in the oh, I don't know, the last sentence over there somehow is something got rubbed off. I'll find out what it was, but that's an appeal to the tax court. The tax court deals with the matter as normal, like a normal appeal, so there's nothing I need to say further on that. Then after that, if the tax court makes a ruling that's not favorable to the taxpayer or either party, they can then appeal to the Court of Appeal, and you have the timelines provided there. And then if that is also not suitable, the Court of Appeal decision is not good, then you can go to the Supreme Court. But you don't get to appeal to the Supreme Court as of right. You still have to get leave of the Supreme Court to appeal to the Supreme Court. Court of Appeal, you have the right, as of right, you have an appeal, but with Supreme Court, you have to get leave of the court. And in most cases with tax, generally they are given, because tax matters generally have public interest, of significant public interest, sorry. Not just public interest, it's significant public interest. And they concern interpretation of laws, so it is useful and good in terms of the jurisprudence of Fiji, that matters can go up to the Supreme Court. Not many cases have been decided by the Supreme Court, but there will be a few in the next couple of years, depending on how the Court of Appeal decides some of our appeals that are currently pending. Okay, so that's all the steps in terms of how you can dispute assessments or tax decisions. And I ask if you can take a note of those steps, because they will come handy later on. And you read the legislation, get a hold of this tax administration decree. You can print it, good. I would actually encourage you to print it. If you print it on both sides, it will come up to about half of this, probably only be about this thick. So it should be okay. So on the thing like this, well, it doesn't have any page numbering, sorry.
So the legislation you're taking into exam is that one?
This one, the Income Tax Act, and the Value-Added Tax Decree. Those are the three I think you need to take, because capital gain tax is already there in the Income Tax Act. I don't think you need to take any other legislation. You should be okay with the three. Unfortunately, you can't take any cases and all those things, so you have to really memorize them. There will be quite a bit on cases too, so a bit of revision on that will be necessary. But only the big cases, I'm sure. Okay, so we've just covered how to go about disputing a tax assessment and tax decision. And now that you know that those are things you can do to contest an assessment, you also need to know that, as I said in the beginning, that even if you do all those things, the recovery of taxes by FOCA carries on. And that's where a lot of taxpayers get frustrated and upset, because they feel they have a meritorious appeal or objection, and FOCA is always calling them up, sending letters, we want our money. Remember one thing, FOCA is under pressure to collect X amount of tax every year. And sometimes the burden of that falls on the taxpayer. Because what happens is this, is that FOCA creates a situation where they interpret the law very broadly or very narrowly, depending on the situation, to try and create situations which will allow them to go back 6 years and collect taxes for 6 years. So what happens is they will do that, and when you calculate for 1 year, they'll multiply it by 6, and then by the time you do the maths and you add all the penalties, the assessment is more than $1 million. And then they go to the business and say, this is how much you're going to pay. The guy has no clue, he has no understanding why it has to be done, but they are asking him, you have to pay it. And he will say, well, I'm going to object. He said, fine, you do that, but he still has to pay. or have find a means to pay. He might have to sell an asset, he might have to get a loan from the bank. A lot of people do that now. Or he may have the money, but he was going to use that money for some other project, for some another expansion of some hotel or something, whatever it may have been, or a factory. He now has to put that money into the to the tax coffers, to the government tax coffers, revenue. So that to me has always been an issue that is a bit unfair. But then again, you have to look at it this way. This particular provision exists everywhere in the world. And this is why. Because if everybody objected to the assessment, every single taxpayer, let's say for argument's sake, and an objection therefore meant that you didn't have to pay the taxes because you have a meritorious whatever objection, then how would the government collect the revenue? There will be no money to pay for the civil servants for this week's wages. There will be no money to pay the contractor for the roadworks. There will be no money to spend for the hospital, for the CT scan. Because nobody is paying taxes because everybody's put their hands up and said we objected to this assessment, we're going to court and none of us are going to pay. So for public policy reason, the laws are designed and effectively says in this particular law that even if you have an objection or an appeal against the assessment, you still have to pay taxes. Section 21(3) of the legislation says that. And again, it is 3. 21(3). Sorry. It says here, subject to subsection 4, which is separate issue, which I'm going to talk about very shortly. The tax due under a tax assessment is payable, notwithstanding that an objection application be reviewed by the tax tribunal or a notice of appeal to the tax court has been lodged by the taxpayer in respect of the assessment. So it's very clear. There's no ambiguity in it. You're stuck with it, and you have to pay. But as we know, the accountants and the lawyers said, no, we want something that gives us some flexibility in the event they can't pay, and it happens a lot. So it allows the CEO Poker to entertain situations like that. In section 21(4) says, section 21(4), yes, section 21(4) says, the CEO may, in certain situations, agree to stay recovery of taxes in dispute under an assessment. It doesn't say much more than that. And that's why I wrote there, rarely granted. In fact, I don't know when it was granted. I think I had one case where it was granted. It was just an ordinary taxpayer. So what happens is that if you make the case to the CEO, you write to the CEO, you say to him or her that if you collect these taxes now, we will go bust. Our business will go broke. We won't have the money to pay our wages. We have loan obligations. We have all these obligations. We just do not have the funds to pay this. But you have to submit all financial documentation, everything. And then the CEO will have to look at it and he will say, I think so. Company A will not be able to survive if we persist with collection of the tax. But it rarely happens. So what they may do is they may say, well, what can you pay in the meantime? At least pay something. Yes, we are asking for 2 million. And if you're going to do an installment payment, it might be 2 million. If you're going to just pay 10,000 every month, you're never going to be able to pay off 2 million in a reasonable time. It's going to take 10, 15 years. So the CEO will never agree to that. So he may say, can you pay 50,000, maybe 100,000 again. Then the guy will be looking around for some money. There was a taxpayer who just came to see me this morning, not this morning, yesterday. He has to pay 4.7 million, of which 2.7 is taxes, value-added tax, and 2 million is penalties. So I asked him, how are you going to do this? He said, I'm selling a property to pay at least 2 million, and I'm going to try and put 100,000 every month. So that's his plan, because he's stuck. But you see the kind of numbers we're dealing with, and that's why this section is important, subsection 4. is not only a stay of recovery tax, but he also has the powers to make time to pay arrangement. That's section 25, which is a different section. It's not connected to that, but if you look at here, section 25 allows him to enter into time to pay arrangement. The second sentence that I wrote there, that's just normally the case. Sometimes they do allow 12 months, maybe longer than that. So they have the flexibility to suspend, where they don't take any money from you while this matter is in court, and that happens very rarely, but in some cases it has happened. And or they enter into a time to pay arrangement where you pay X amount of money every month towards your tax liabilities while the case is pending. But even if you don't have a case pending, but you just don't have the means to pay upfront, you agree that you have to pay. You see, section 25 is useful. Section 25 of the Act is useful even if you don't have a matter in court. You can still say, look, Commissioner, I agree that I have to pay 2 million. It was a mistake, but can you give me a time to pay arrangement? So that is what is allowed for in section 25. He has the powers to do it, but the discretion is all with the CEO. Just going back to the second dot point, in some cases, you can actually apply to the High Court for orders to stay recovery of taxes, but it is hardly done now because of the way this law is drafted. It's very difficult. In the old Act, it wasn't. All these things were not there. The case that comes to mind is Sun Court case. Maybe you want to write it down. Sun Court, where the court exercises power to grant a stay of recovery of taxes. Sun Court was a hardware business, but I think most of you would probably remember them. They've gone bust now, but they had a lot of issues with the tax office. And they went to the court, High Court. It was before this law came in, and asked for a stay, and they got a stay. So Sun Court case, you go back to you'll probably find it. It might throw up a lot of other cases, but if you zero in on the one which is the Commission of Inland Revenue, try and pull out that case and have a read of it. It might set out the principles and so forth. So the fourth point is what I was trying to say earlier, that it can be very a powerful weapon for FOCA, and also, but there are provisions there in the law that helps the taxpayer in the unique situation where he may need help. Okay. There are other powers. Sorry. Yes, what I was dealing with just now was general powers in relation to tax recovery, but now we're looking at specific powers. You might have heard of garnishee orders, right? They have the power to garnish bank accounts, and in fact, it's quite wider than we think. Section 27 was subsequently amended, and basically, if you owe money to the tax office, and you are receiving, say, for example, rental income from property earning income, FOCA can give a notice to that particular person, your tenant, that instead of paying your landlord that rent, you pay us. So then you don't get the money. Money goes out back to FOCA. Same thing with banks. When money goes to the bank, say for example you've deposited your sales for the day or the week, 100,000 has gone into the bank. If FOCA has sent a garnishee notice to the bank, they have to remit the 100,000 or whatever portion of it related to the tax. Pay that to FOCA. So they don't need any court orders for that. They can do it like that. They write a letter. But normally these letters are also copied to the taxpayer. They're supposed to be sent to the taxpayer. So they can clean out your bank account before you even know it. So remember that too. And not only that, their powers are a little bit more wider now. If they feel that you're putting your money in your wife's account or your son's account, or your son might be just a student in high school or something and your wife is not working, but they know that through their research, they know that that fund is from the sale of some business proceeding and your business has not been paying the taxes, they will take out the money from their account. But the question then can be that it's a bit unfair because, say for example, your wife might have inherited some money from, say, deceased father or something. 100 grand was given to her, sitting in the bank account, maybe just collecting interest. And then Foka thinks that 100,000 is the taxpayer's money, her husband's money, and they take that money, and then the lady doesn't know, so she's been deprived of her property, isn't it? So then she has to then make representation to the CEO of Foka and say, hang on, that money is not my husband's money. And they say, how you say that? Then you have to show the paper trail, how you can prove that that money was actually given to her by her father, or through the will when he died, or maybe it was a gift. So that's why I put that point there. The problem may arise in determining source of funds. So it is tricky. And some of the cases I've dealt with, money has been taken. I was just thinking of a case that I dealt with. Someone came to me some time back in relation to his money. Anyway, so that allows them this kind of power to get money directly out of bank accounts and so forth, from your bank account or your family members or your friend's account, as long as they can show or trace a reasonable conclusion can be reached that that money is somebody your money, even though it's in a different account. So Ganeshi is a powerful weapon, and Foka will use that as their first step for recovery of taxes. They love using Ganeshi orders. The second one is also very well used by Foka, but they don't use it as a first instance. They like to use this as a last resort. And departure prohibition orders also apply to company directors and shareholders, so which are actually quite wide now. So it's not just you as a person who can be subject. If you are a director of a company and the company hasn't paid taxes, you can be in trouble as well. So it's not good to become directors, in my view. There are just too many obligations, because you might be a silent partner in the business. You might not really be the main mover and shaker in that company. And if they feel that you are leaving the country for whatever reason, they'll put a departure prohibition order on you, and you're stuck. You can't travel. And then you say, hang on, where's, because all the other directors might have left the country pretty quickly before anything happened. And then you're the last one standing there. Then all the burden then falls on you, and then you can't travel out. You can only travel out if the tax is paid, or if you make arrangements satisfactory to the commissioner to pay the taxes, maybe an installment or something, or you provide some security, properties or something like that. Then you might be able to travel abroad. But I know one particular client of mine who hasn't been able to leave the country in the last 7-8 years now. He's almost broke, and he's a European fellow, but he's locked from every side. His banks are under Ganeshi. He can't travel. He can't sell any properties because there are charges on the property. We'll come up with that shortly. All his assets are under Foka charge, Kevin. So everything is locked. He's paralyzed. So he has to use other people to actually be the fund man for some businesses. So if he has a good friend, Tom, for example, he would ask them, look, I'm going to run the business and all that behind the scenes, because you can't really stop them from doing that. But Tom might coordinate everything. He might open a bank account under his name, and everything is being done through the guy, the first guy. But the brains behind the operation is this guy, the taxpayer, my client. So the money is able to go in there. But he can't, for example, use land. He can't borrow money because the assets are under his name. So he's stuck. There's only so much you can do. You might be able to run a small business, but if you want to do a development kind of business involving land, the land is the one that's under his name. And if he wants to mortgage it and something like that, he can't do anything. So he's stuck, and he owes millions of dollars to the tax office. Rightly or wrongly, I think wrongly in my view. That's why we had the case in court. And it's supposed to be in court of appeal, but that's another issue.
So how does basically law So he could sell one of his assets to pay off the tax, right?
We could do that.
Yeah, but if Furka's locked his assets, locked his bank accounts, and all that, how does Furka expect him to?
They don't expect anything from him.
No, I mean to pay off that.
Well, Furka can do one thing that they can do is sell the assets.
Furka will sell.
They have the powers under the law to do that when you come across that deal. They also can sell assets, and they've done it in a number of cases where they.
It's like a receivership.
Yeah, sort of like that. But they don't actually take over the business on it. They just look at the assets. They can sell motor vehicles, chattels, everything. And if you look closely on some of in the papers, you will see that they do auction or tender by private sales and all. You remember that company? There was a TV company that was here, not Sky or what's the other company that came here? They had a satellite dish. Huh? Yeah, PBS. They went bust, and they took over all their assets and they sold it. And my friend, because I was working with my friend, we bought some of those stuff. It was on an auction, not auction, it was like private tender. You just give your price, they look at it, they see if it's good, and they'll sell it to you. So some tables, counters, and they were all PBS stuff. Some computers, my friend bought it. So that's how they recover some of the taxes. So they're able to do that. That will be discussed shortly, I think, in the next one. Yeah, that's what we're dealing with here. So the first one is, Furka can place a charge on the property. If a person owns a property or a company owns a property, they can place a charge on it. They can put it on anything really. It's quite broad, even an intangible asset, share, security, equity, financial asset, anything really. They can put it on any real asset and even other things that are not real, like intangible. So if they place a charge on it, they can also place a charge on the shares. So if you own shares in FMF, Flour Mills of Fiji, they can place a charge on it, and the guy will not be able to sell it to anybody else, even if he wanted to. Furka can step in his shoes and sell his shares to somebody else. It's a bit unfair, and it actually happened to this guy, the one who was my client. They passed a law just 1 week before that it happened, and I didn't know about it. And I asked them, "Hey, where is the provision for this?" Where they stepped into the shoes of the director, but they then sent me very promptly the amendment that came out. This was before we had the election, and those days, the decrees you can just sign it anyhow. Right? So that's how they did it. And to be very frank, I mean it's a bit political here now, but that particular law was designed for this particular taxpayer. So it was a bit like a vindictive kind of thing, where they actually went for this particular taxpayer. I don't want to mention the name or anything like that because it's a sensitive area, but that gives you the idea of when you're not in a democratic environment, what can actually happen. And so there's no oversight of the laws. So nobody can really say for certainty, apart from myself perhaps, that law was brought in just to hammer this fellow so that he would lose his shares, and the guy who would buy it was the man who wanted to take over his business. You see? A man who wanted to take over his business because they had a fallout. He was another shareholder, but he was not a majority shareholder. This fellow had the taxes he had to pay. So Furka got his shares, sold his shares to this guy who took over the whole business. And this fellow was sidelined.
So when you're explaining it like that, I'm thinking of how when you have property and you have ownership, it's yours against the rest of the world. And you have a title.
Yes.
Like a title, for instance, it's because we're saying intangible property.
Yes.
Shares. So that means, so that the ownership, when you don't pay the taxes, the ownership transfers to
only when they exercise their powers under the act. It's sort of they step into your shoes, and it's legally done. That was one of the issues we had when we sold the first properties. I was in Furka that time. I'll just give you a bit of background. There was a taxpayer who couldn't pay his taxes. I think it was a company. It was Isipico, ISIPIQIO or something like that. There's a judgment on Peckley as well. They couldn't pay their taxes, but they owned a nice parcel of land on Savu Savu, right in the beachfront, and there was some inside too. So they couldn't pay their taxes, but these prime lands were there. And then we organized an auction, and Grey Medan came and did the auction, and we made money out of it. But then the next issue came in, the transfer. How do you transfer it? Because the ISPICO didn't sign any transfer. So then we had to go back to the court and get a special order to allow for the registered title to transfer it to the new owner. So they stepped into the shoes of that original owner. ISPICO never signed any document that we agreed to transfer. You can't force them because they obviously didn't agree with it. And they probably weren't even in the country by then, I think. Whoever the director was, or the authorized signatory or whatever. So the court had to make a bit more clarification they had to give in a particular order that was used then. The court basically said, we order the transfer of this property to this company, the new buyer, whoever bought it, through the auction. And that order was then taken to the register of title, and that forms part of the transfer documents to the new owner.
So even though you're a property owner, you have that ownership under that administration, the court can step in and take away what rightfully
Yes,
belongs to you.
but only through the process of law. It's not an arbitrary thing done just like that. You can't lose ownership like that. That's why this thing, even the CEO of FUCA, he cannot sell a property without getting the court order. In relation to this one, it is the court order. The Ganeshi, the DPO, he does it on his own. He can do that on his own. Bank account money, all that stuff he can do. But when it comes to these things, to this process, Section 28. Section 28, he actually has to go to court. Let me see this. Tax or charge on property. So Section 28 is a whole series of sections, and I know this was one of those provisions that was strongly debated by the team, our team and the accountants and lawyers before it became law. And it actually sets out how you go about doing it. And there is some balancing exercise here too, but it's not straightforward. Like the way I said it on this, it may look very simplistic, but no, the law sets out in a bit more detail what has to be done. And you can't just do it anyhow. So for example, if there's a mortgage already sitting on it, that is secured still. So the bank doesn't lose his thing, because the bank was the guy who put the first charge on it, so to speak, and so that's secured. So the FUCA has to sell the property at a price, ideally, where they can pay off the bank and any other secured debtors, and then take their money out of that. And if there's any money left after paying all the taxes, then it should go back to the taxpayer. And you also have to take out the cost of getting all these court orders and the administrative costs. You take out that, and the balance sum is given back to the taxpayer. But the end result is he lost his asset. We don't know what price FUCA will sell it, but because we did it through the auction, I remember we got some good prices for it. And there were a lot of buyers, surprisingly, because Sabu-Sabu, you can imagine, there would be a lot of good buyers. The Palangis, all of those people got a lot of money there. I think we have to run around looking for money, but they're very quick. So we sold about 4 or 5 properties. So that's a good provision for FUCA, not so good for taxpayer. The only problem that I have now is that like I said earlier, they keep shifting the goalposts. And so, for example, that situation where his shares were sold, it's a little bit more complicated than that. But if it can be used for the wrong purpose too. And how well will the court stamp out all those kind of things, I don't know. But my client, the one who has been a victim of it, is really struggling right now. And he can't even go out of the country anyway. Collection of tax by distress in sale, Section 29. So you can sell the personal property of taxpayer. So if a taxpayer, particularly an individual, because personal property would be individual, can't be a company or something like that. But if you yourself haven't paid taxes, say for example, young Tias, you owe 100,000 in taxes, but you've got some nice fridge at home, got a good flat screen TV, you've got tables in In each of your room, you got air conditions. They can take all of those and sell it. Naka, then you'll be left with nothing. Only the clothes you're wearing.
Person can be right on the restaurant.
Huh? Yeah, that's right. But they give you notification and all that stuff. And so you do have these some avenue to protect yourself. So there will be a notice given first before they actually do it. So if you pay it up before that time, you're safe. But again, there's a good number of subsections. It goes up to subsection 8. Or is it more than that? Oh yes, subsection 9. So have a read of that, because we don't need to go through every single clause in this. But it's good to read it, so that you're familiar with it. They can also, a third dot point, section 30 is seizure of goods. They can seize goods, but only in relation to VAT, not income tax. Now I'll tell you why. There was a separate law brought in for this, because VAT, as you know, is charged on goods, and also services, but mostly goods. So if you're running a supermarket, and you are selling goods, you're charging VAT, but you're not paying the VAT to FOCA. For whatever reason, you're being nasty, you're being naughty, the taxpayer is just being flagrant of the law, is abusing the provisions, it's not helping. FOCA can say, no, this is unfair. You are collecting the VAT, but you're not remitting the VAT to FOCA. We're going to seize your goods. You won't be able to sell for a period of time. They normally specify the period. They've done it a few times. They must be stored in a place approved by the CEO or the authorized tax agent, tax officer for storage of seized goods. So they can be taken away from the supermarket or the shop, if it's a jewelry shop or hardware shop, whatever, and they put it in a warehouse. They've got a warehouse in Nakasi. I don't know whether anybody has seen that. But there is a big building down there, just outside of the police post, where they dump everything there. Really nasty place, but everything is piling up down there. I've been there. But so they can do that, and they basically stop your business with seizure of goods. Now I'm not saying that seizure of goods is then used and sold, but they can. They don't sell the goods. They can just hold the goods. But after a certain period has expired, and if the taxpayer doesn't pay up or doesn't claim for the goods, then they can sell it. But there is a timeline given under the law. Right?
So what happens if those goods are damaged while waiting for that storage?
If they were damaged, then FOCA can be liable, and if they were negligent. But if it was just a normal wear and tear, while pushing it into the carrier or something like that, and some of it got damaged, then they can't claim compensation for that. But if they were negligent, if they were picking up the TV and just throwing it on the ground like that, then we can sue them for that. We did that in one case. Jay's Holding Limited, have a look at the judgment, where the goods were released, but they were given in a damaged condition. All the cans of Woodstock, Woodstock, I don't know if it brings me, I don't know. Some of you people might be drinking Woodstock. Huh? Woodstock? But these guys had Woodstock and a few other brands of alcohol beverages, and it was seized, and they didn't keep it in a cool environment. It was a hot place, tin shed and all whatever. And obviously the heat affected the cans, and they busted some of them. When he got it, half of them were busted. These are big cutters, plenty cutters, not just a few cutters. Like the whole room would have been full. And he wanted to claim against FOCA, which was fair enough. I think he had a good grounds. The way the taxpayer was being very fussy and difficult, and I knew it was going to become a headache for me at some point. So I decided to go and take it to another lawyer, do this part of your case to someone. We did the case to get the goods all released, but he gave it to another solicitor to go and claim against FOCA. He was asking for 1 million, 2 million. FOCA was prepared to pay him. So we were prepared, we were going to get some money out of him, maybe up to 100 grand or something. But he wanted more money. Sometimes we have taxpayers, clients like that, who will demand substantial amount. And because I've got to maintain relations with FOCA in such a way, I don't want to be seen as being unreasonable too. So I said to him, look, go to another lawyer. And he was okay. He comes to me for other things, but the point is, you make those calls. But just going back to your question, yes, we can make. They can make claims for damages, loss, and so forth. The other power too is Section 32. It's different from 30. Section 30 just sees the goods. It doesn't stop their business. They can still do other business. But this one, the next one, in only relation to VAT, PAYE, service turnover tax, and fringe benefit tax, not income tax, you can actually close the business. You get that yellow sticky tape, you hang it around the front of the shop, it's closed. They did it once or twice. They don't do it that often because they don't want to be seen by the government, particularly government, to be discouraging business, because
It doesn't do
the business is got employees. If maybe the business owner is an idiot not paying his taxes, but the poor staff, they're not going to be able to earn any money whilst they're on leave, while this business is closed for whatever period of time. So that sends out the wrong message, and I know our number one and number two would have got very angry about those things, so they don't do these things, because it's not nice. Publicly, it's too visible and too blunt, so they won't do this. The last two ones they won't do, but they do have the power. If they have to, they will do. But I think for public policy reasons and political reasons, they don't actually do it. And it is only in relation to VAT, PAYE, and STT and FBT, because those are taxes you pay on behalf of other people. The VAT you collect from your customers, so you should remit that to FOCA. PAYE you pay on behalf of your employees. Service turnover tax is not, that's service turnover tax. That's also similar. You collect the tax from your customers, like McDonald's, they collect 6% or what, service turnover tax. FBT as well, fringe benefit tax, is paid on behalf of the employee. The employer pays it. So only in relation to these aspects of taxes, these things can apply. But if it's income tax, they can't close your business. That law does not apply to if your business owes income tax of their own. The company owes income tax to FOCA, they cannot close it down. Now, other things too that they can do is refunds. You might have a refund in your value-added tax column, money that you can get back from FOCA, because maybe you import a lot of goods, so you paid the VAT and then you're entitled to claim back the VAT. We'll talk about that later on next week. So you might have in your ledger, sitting on your VAT ledger, you will have $10,000 that could be refunded to you. But in your income tax ledger, you are supposed to pay them about 20 grand. So FOCA has the ability to wire that money across to reduce the income tax. So your VAT ledger becomes 0, and your income tax becomes 10,000. They wire, they offset it. Because a taxpayer will have a number of ledgers, for especially business. They'll have a VAT ledger, they'll have a service turnover tax ledger, they'll have a fringe benefit tax ledger, they'll have provisional tax, income tax. So there might be about 4 ledgers or 5. And if you have any refund sitting in any of these accounts, and you have an outstanding tax in one of them, or 2 of them, or whichever, then the money has to be shifted into these to reduce. So the poor guy is thinking he's going to get a refund on one side, and a check might come. You'll be surprised, a lot of businesses actually operate on the basis of the refund. That provides them their cash flow. And when they don't get it, it can cause other problems. But the key is then not to have any amount owed to FOCA. If you don't have any taxes payable, then you will get the refund. Within a month, you should get it. But if you have other taxes owed in some other columns, like income tax, then it will go across. So people are unhappy in those kind of situations. But I think it's a fair thing, because why should FOCA be refunding you something when you owe them money? If you owed me $10 and I have to owe you $5, you're not going to pay me $10 and then wait for me to give you your $5 back. you'll probably just give me $5, won't you? And say, that's it, we balance the ledger. So that's the same way it happens here too. Also, bad debts. Under the law, not necessarily in this provision, but there is now a provision. You see there, section 33A was an amendment done. Is that bad debts it can arise when FOCA makes an assessment after a number of years. They say this particular taxpayer has gone broke. He's now bankrupt. He's nowhere to be seen. And in the ledger, it's still showing $10,000. We can't keep having his $10,000 there. There's no way we're going to collect the money. FOCA also makes that decision internally. They also do a review and say, oh, well, this person A is like a hopeless case. We can't collect. Just like businesses, we have to make decision. If a client, for example, hasn't paid over a long period of time, we might have to then accept that he's not going to pay us, and we declare it as a bad debt, and that becomes an expense. So FOCA does that too, where a lot of debt gets wiped out. And we're talking about the millions, not just $5, $10, $100, $1,000. It's in the millions. Every year there's a certain amount of money that's getting written off. Government doesn't like doing it because then it complains to FOCA, why is it that all these things are happening? You should be able to collect it before all these things become bad. Yeah? So FOCA is under pressure not to make too many bad debts. Yeah? But unfortunately that's the reality. So what is this? Is that once it becomes bad debt, and let's say for argument's sake, that particular guy who had his money, taxes wiped out, he then starts making money again. He puts his life in order, he then starts getting into some good investments, he gets into a logging business, and then a tax officer sees that and says, hey, this guy, just 5 years ago he was busted and he wrote off his debt, $10,000. He's now back in operation. They can reinstate it. Worry. They can reinstate it and he's back to square one again.
So what are the taxmen is hated?
I understand. So they can reinstate that debt. And before he knows it, he's getting a letter and says, bro, remember when you were running this business, the video library shop? You owed us 10,000? Oh man, I had a marriage breakdown, I was this, I had depression 5 years. And now you're coming up for 10,000. Let's say for argument's sake, he gets back. That's what happened with, I remember making this joke when we did a presentation with the Video Law Society. A lot of the super grammar students, former students, I don't know whether anybody of you studied in super grammar, they came for a reunion here at the super grammar school. They had this reunion of all the ex-students. And what they didn't know was that FOCA a few months before that had been directed by government, I was there at that time, to reinstate all the bad debts. So those people who had left the country, their debt was written off because they had been out of the country for 10 years, 15 years, 20 years, sometimes very long period. So their tax debts had been written off way back. But because government said, if any debt is above $10,000, reinstate it. Across the board, doesn't matter which taxpayer it is, just reinstate it into the records. So when they reinstated, they issued the departure prohibition orders at the same time. So all these people came in for holiday, warlag, drinking, party. When they got to the airport, they found the DPO was sitting there. They got stuck, and then they all had to run back, and then they try and sort out and make a payment for it, because they thought if they came over for a holiday and to watch these games, or what would they call not games, the reunion, then obviously they have money to pay something. So a lot of them did pay back. So if you ever migrate and you think of coming back and you had some outstanding tax, forget it. Don't come back. Yeah, that's one of the realities of the law. Eh? Director of company can also be personally liable for the company debts, which is, I think, a little bit harsh, but it only relates to VAT, gambling turnover tax, service turnover tax, and withholding taxes and other withholding taxes. So there are some of those exceptions there. And I have a client right now who's battling with FOCA. No, not really battling, I think she's given up now, but it was more than 10 years ago, and she was lumped in with the company taxes. FOCA always citing this provision, quite rightly, but she keeps saying that I was not That's why I said that there are some exceptions. If the director didn't know anything about those tax debts of the company, maybe she was as in this case, she claims she was a silent director. Her husband was the more physical one, the one going on. Then she can be absolved of it. But in this case, Fuka had evidence that she was involved with the operation of the business, so she knew about the tax debts. She knew it had been incurred. So therefore, they made her personally liable for the taxation debts of the company. The company doesn't operate anymore. And she has some properties and she's got them under charge. Fuka has a charge on those properties. Just like the one that I was telling you earlier. They placed a charge on her property. It's a family home. They're saying maybe you should sell this property. She owes about 900 grand. Not she, the company owed 900 grand. She's now personally liable for about 900 grand. So she's stuck. And I've told her that, look, that's the only way you can get away with it now, is you got to sell it. If you want to have peace and harmony and go no more problem with Fuka, you have to sell that house. So that's what the law says. You can't do much about it. Poor taxpayer though, but what can you do? If a shareholder of a company, single shareholder company, these are single shareholders, if the shareholder, now this is the flip side, it's not the one like this one, it's the flip, the other way. If the shareholder of a single company becomes bankrupt, the individual becomes bankrupt, the company has to pay for the tax of the individual. You see, under the Company Act now, you can have single shareholder or single director or whatever you call it. One-man company. Before, you could never have a one-man company. The new Act allows that. You can have one-man company. So me, Bupendo Solanki, I can form Solanki Limited. And I'll trade in as Solanki Limited and do everything, my investment, property, everything. But if I as an individual go bankrupt and all the money was in the company has to pay my taxes. You see? Which is good in a way, but can be abused as well. It's not a well thought out provision, but it's there. Let's check if I'm coming to the end. Yes, 10 minutes to go. We discussed the Manoj Kera case last week, and I was talking about prohibition, the departure order, the constitutional provision. That was one of my cases. In fact, all three of them are my cases. Were unsuccessful though. Oh, sorry, the first one was successful. Why I just put those cases up there was to just give you some idea of the kind of issues that went up to court in relation to these laws. Not the Income Tax Act or anything, but in relation to the interpretation of these laws. There's a few other cases, which just skipped my memory, which I will post up on the practically when I have a chance to do that, so you can read it. But Manoj Kera was a case in which the taxpayer wanted to travel abroad. He was a jeweler, and he had actually falsified his VAT returns and created fictitious invoices, and he was able to claim substantial VAT refunds. It goes into the millions as well. And Fuka had paid all these refunds to him. And once they found out that it was all fraud, because somebody eventually dropped him in, they prepared an assessment, they issued it, sent to him, and they also issued a departure prohibition order. Now the unbelievable thing is this fellow Manoj Kera was able to still travel, even when there was a departure prohibition order there, he was still able to travel. Now how did he do that? This is where the linkages between Fiji and the immigration department was a bit lacking there. All he did was he just claimed that my passport, the one where the departure prohibition order is on, the number, there's a number on every passport, isn't it? So that also is included in the departure prohibition order. He went into the immigration department and said, I've lost my passport, can I apply for a new one? They processed it, he got a new passport, and he traveled again. He traveled a couple of times to India at a good time. He went to Dubai. And our Fiji people had no clue. Our Foka people had no clue. Immigration allowed him. So that's when there were two things that came out of this case. Then we had to develop an MOU with immigration to tell them that if anybody who has an existing passport that has a DPO, because they knew that the passport had a DPO, so they shouldn't have processed the second passport. They should have automatically told Fuka that he's applying for another one and then give him the passport, because he might need the passport, but then transfer the DPO to the new passport. So he had managed to get away with these things for a year or so. And finally, someone wised up and realized he was traveling, and they then stopped everything. He couldn't travel again after that because they narrowed everything down. Immigration sorted out their internal systems and all that, and he couldn't travel. So he came to the court and saying that this departure prohibition order is unfair and so and so and so. And our judge Jiten Singh was a judge, and he heard arguments, and he held that the departure prohibition order was constitutional because they said it was unconstitutional because it was fair and reasonable in a democratic society. In this kind of situation, a DPO is fair. Now, we've looked at a number of sections here, and I can see the view from you that some provisions are unfair, some may look like it's very draconian, some may be unconstitutional, if you would argue, like the deprivation of property and all those things. And those are matters we could one day end up taking to court and saying that this is unconstitutional based on the current constitution. But this was a good case because it then allowed the court to make a decision that it was not unconstitutional, because a lot of people had an issue with the fact that the CEO himself could just make a DPO. It didn't have to go to the court. Anybody else who wants to stop any person from traveling, say for example in a civil proceeding, if I don't want young Tes to travel because he owes me some money, I go to the court and I get this special, I forgot the name, the Latin word, Vitsni something, I forgot it, it's so hard to pronounce. I'll get an order from the court, I'll submit an affidavit, I'll show what the case was about, maybe I have a judgment already against him, and I know he's traveling because I've heard he's selling his assets and he's liquidating. So then the judge or magistrate will give that order, and then I give it to immigration, and then if he tries to travel, he's stuck, he can't do it. Sometimes you can make these applications ex parte because it can be an overnight thing. You just know he might be traveling tomorrow, so how the heck are you going to be able to serve him and all those stuff? So you don't serve, you get an ex parte order to stop it. That's in the civil proceeding. But in the DPO, it doesn't work like this. I remember one case when I was in Phuket, very quickly, there was a staff of ours, quite unbelievable, that's what I'm saying in politics. A staff of ours in Phuket, not my staff, but he was working in Phuket. Some guy from RBF, the financial reporting unit, what do you call it, Razim Buck's team, they tipped off Phuket saying that this fellow had about 50,000 in his bank account. They didn't know though that his mother operates a canteen in Mongolebu somewhere, and she was depositing the same money in his account. They didn't do their homework. I didn't even know at that point too. But this fellow did have money in his account, but it wasn't his salary. Salary might have been going to some other account. They thought that he was getting some money from some sideline business. Foolishly, very foolishly, they granted him leave to travel overseas for a holiday, and then this thing came up. So the CEO has already given him leave to go overseas, and he goes to the airport. And just imagine his shock when he finds out that Phuket quietly put a departure prohibition order on him. So angry, he came back, and it was a big issue. But it shows that you can use these laws for bad purposes. If your intent is bad, if you don't have it in good faith, you're not doing it in good faith. And this poor fellow was eventually able to explain that that money wasn't what the people thought it was. He wasn't smuggling or doing something stupid, illegally. It was money that was coming from his mother's canteen. It was accumulation. I don't know how much it was, maybe 20,000, 30,000. But the DPO was issued in the night, so I had to go to the office in the night one day. And they gave me a very brief synopsis about the thing. I said, well, I didn't make the call, but they just wanted me to be there. They prepared it, then they sent it to immigration, and the next morning he was traveling out. He's already had his leave approved, he's going to New Zealand, as he always does every 6 months. I think he's got some families there. And he couldn't believe his own office had put a departure prohibition order against him. So this is Fiji. I'm just telling you some of these things just to give you an idea of how some of the laws can be manipulated. So Manoj Kera then was not able to travel, and the court held that he went to jail eventually because he was convicted for some serious offences. Sinohydro is about extension of time to object, which is a difficult case, but we lost that one, and Logan as well. They're all to deal with time to object. One is to deal with objecting, and one is to deal with appealing to the tax court. There are some other cases which I haven't included, but I will post up on the network. and have a read of them. But like I said, I've given you some hint that this will come, and it's not a very difficult question anyway. If you just try and read up the law and go through the slides and understand it, memorize it, the legislation you'll be able to take it with you, so it shouldn't be too much of a problem. And I'm sure you can get an easy 10 marks there. I'm not going to tell you what the exact question is, obviously. But does anybody have any questions? MPS? No? Next week we're going to do VAT. So VAT is it's not as simple as it seems. So bring your thinking caps. Next week we're going to talk about VAT, VAT. It should be interesting as well. There are 2 weeks dedicated to VAT. So we should be okay. Now I've just, what I put on the slide is not everything that's in this law. I mean, it's impossible to do that in 2 hours. But I would suggest you find the time to read it. I mean, it is interesting, and for your own development as well as. So again, thank you for your patience.